Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeev Bhatia again, and we are back with a new video on your legal Darpan, which is the peek into weekly legal current affairs. And also, we are on the episode number 7. So, all the people who have joined right now or who are watching this for the first time, do make sure that you hit on the like, share, and subscribe button. And also, don't forget to hit on the bell icon for all the regular updates so that we can always remain in touch with you, right? So if you are new to the channel, you might have seen that we have discussed a lot of sessions before this regarding the current affairs, and we have been in continuous discussions for the same. So if you want to be updated regarding that, please make sure that you are following us on Telegram under the name of CLAT @Pratham, where we put up all the news articles and news updates that comes regarding law, and all the quizzes that are being held on regular basis are uploaded on the channel itself. Now, the first news for the day. So the Supreme Court has upholded the constitutional validity of the economic weak section quota in a 3:2 verdict, right? So what has happened is that the Supreme Court has upheld that the 10% reservation for the economically weak sections among the forward caste in the government jobs all across jobs in colleges across the country. Now, of the 5 judgments delivered by Justice Ravindra Bhatt and CJI Lalit gave distinct judgments, right? Reading out the verdict, right? Justice Maheshwari said that the 103rd constitutional amendments for the EWS quota was valid and they do not violate the basic structure of the constitution. So they are saying that it is not violative of the constitutional's basic structure. And also he said reservation is an instrument of affirmative actions to ensure all inclusive march towards the goal of an egalitarian society, right? So it is all inclusive in nature, it is providing an equality in the society and equity in the society. He means that from this line. Now coming to the next part, what was the majority view on this particular topic that was coming out from these judgments? Is that Justice Dinesh Maheshwari said that it cannot be breach the basic structure of the constitution. EWS quota does not violate equality and basic structure of the constitution. Reservation to existing reservation is violative provisions of the constitution, he said. Justice Maheshwari went on to say that reservation is an instrument of the affirmative actions by the statute for inclusion of backward classes, because he wanted them to be a part of it. Now basic structure cannot be breached by enabling state to make provisions for education, he added. And also reservation is not just for inclusion of socially and economically backward classes into the society, but also the class so disadvantaged, right? Any class which is under disadvantage should be included in such a reservation policy. Now what was the minority view that came up in this entire thing was that Justice Ravindra Bhatt said that what is to be described as benefits by the union cannot be understood to be a free pass, but as a reparative mechanism to have a level playing field. Their exclusion discriminates equality code and violates basic structure, right? And also reservation is contrary to the essence of equal opportunity. The 103rd amendment practices prohibits forms of discrimination, right? Because if you are giving someone a reservation under colleges and jobs, then definitely it is not the essence of providing equal opportunity. Now he also noted that the bulk of economically weaker sections belong to SCs and OBCs, right? Scheduled castes and other backward classes. Now CJI UU Lalit concurred with Justice Bhatt, and also what is the present view is that while upholding the validity of the economic weak section, Justice Pardiwala said reservation is not an end but a means to secure social justice. He said it is necessary to review the method of identification of backward classes for reservation. The idea of Dr. Ambedkar was to bring reservation for 10 years, but it has continued. Reservation shouldn't be allowed to become the vested interest, he said. Now also reservation has been provided to historically disadvantages cannot be basis to contain other disadvantaged group unable to progress, and say that provision can't be made for EWS through amendment. Reservation through economic criteria per se not violative. He said that also, right? It is not violative in nature, and also it is something that can be done on the economic criteria too. Okay, so that is the current view on the reservation itself. That is the present view that the judges are holding on the same. Now coming to the next part. Now children have the right to company of both parents. Serving contact with one parent snaps emotional and also psychological bond that the child has formed with the parents. Now you can see that the court is just not looking on the surface level, it is also going deeper than just understanding what are the emotional and psychological aspects of this enclosure will lead to, right? So the Kerala High Court said that the settled position that while considering custody matters, the court must pass orders ensuring that the child is not totally deprived of love, affection, and company of one of the parents, right? Because genuinely, when the parent starts fighting, a child is left in between and they don't have any option and they remain helpless. So they don't want the child to be deprived of any love, affection, or the companies of one of the parents. Now, coming to the next part is that the division bench that was comprising of Justice Anil K. Narendran and Justice P.G. Ajit Kumar observed that if the child is denied with the opportunity to interact with one parent, it will certainly cause snapping of the emotional and the psychological bondage, right? So there will be no bond that the child will share with his parents because of such deprivation that is being caused by such needs. Now, while stating so, they also take the note of the position in Yashita Sahu versus State of Rajasthan, where the Supreme Court also held that the child has a human right to have the love and affection of both the parents, right? So this is a human right of the child to get the love and affection, and also taking away the contact will snap away the emotional and the physical, psychological bond that is there with the parent. Now, the court said that if does not mean that if parents are at war each with each other, does not mean child should be denied the care, affection, love, or protection of one or the other of the two parents. A child is not an inanimate object which can be tossed from one parent to the other. Every separation and every reunion may have a traumatic and a psychomatic impact on the child. That's what the Supreme Court has said, that you cannot toss the child here and there. उसको इधर उधर नहीं फेंक सकते, because separation भी हो चाहे reunion भी हो रहा हो तो भी traumatic एक experience child के लिए हमेशा रहता ही है. And also that the custody is given to one parent, the other parent must have sufficient visitation rights to ensure that the child does not lose social, physical and psychological contact, right? क्या आप उनको इतना नहीं दूर कर सकते, या sufficient visitation देना पड़ेगा ताकि उनका एक social, physical और psychological contact हमेशा बना रहे. Now, coming to the next part, it also emphasized that only in extreme cases that one parent should be denied contact with the child, reasons must be assigned if one parent is to be denied any visitation rights or contact with the child. There has to be a proper reasoning. कैसा क्यों किया जा रहा है? There has to be a proper code of conduct that has to be seen, that why is such a thing happening with the child. Now coming to the next part for the day, that can't issue writ of habeas corpus against the person who is residing outside the territory of India, right? So this is what the court has said in Madhya Pradesh, right? I'm sorry. So now what was being said is that the Indore bench recently held that the writ of habeas corpus cannot be issued in front of a person who's residing outside the territory of India. Now, what does habeas corpus means? That it is a recourse in law through which a person or can report an unlawful detention or imprisonment. It means basically bring the body back, right? So that is what is said to be called in under habeas corpus. It is a writ. And also it is basically for people who are being put in prison, unlawful detention, they've been detained, arrested, whatever. So habeas corpus is basically bring the body back. Now, coming to the next part is that Justice Vivek Rasia and A.N. Kasarwani noted that the petition was liable to be dismissed since the petitioner was praying for something that was outside the scope of its power under Article 226 of the Constitution of India. Now, it is also clear that High Court shall have the power throughout the territories in relation to what and which it exercises jurisdiction to issue any person or authority, including any government, within whose territory and direction order or writs for the enforcement of any right. So basically, अगर कोई इंसान इंडिया के बाहर रह रहा है तो bring the body back की writ issue नहीं की जा सकती because they are not falling under the jurisdiction of that court. Therefore, the High Court can issue a writ under Article 226 of the Constitution of India to any person within its territory. Thus, this petition is not maintainable and liable to be dismissed on this ground alone. ठीक है, तो उनका प्लेस ऑफ जुरिस्डिक्शन नहीं है, तो वो आर्टिकल 226 के अंदर कॉन्स्टिट्यूशन ऑफ इंडिया के अंदर उस टेरिटरी के किसी भी इंसान को बुला सकते हैं, बट वो उसकी टेरिटरी में नहीं है, सो दैट इट्स नॉट पॉसिबल. नाउ कमिंग टू द नेक्स्ट पार्ट इज दैट फैक्ट्स ऑफ द केस were that the petition was earlier residing in Netherlands with her husband and daughter. Due to matrimonial discord, she could no longer live with her husband. Now she filed a complaint against him before the authorities in Netherlands, pursuant to which husband was directed to stay away from the petitioner and the child. Now, there was no source of income that the petitioner had, though of the moving back to India with the daughter. However, owing to the lands in Netherlands, she couldn't take the laws in the Netherlands, she couldn't take the daughter out of Netherlands itself. Left no other option, she came to India, left her daughter behind, and in order to get the custody of her child, the petitioner moved to the court under the writ in the nature of habeas corpus that bring the body back. So that was the case that was happening in this scenario. Now, the draft law to curb the menace of online gamble is prepared under the consideration of Rajasthan government that informs the High Court regarding that they are trying to create such laws to reduce the gambling in the state itself. Now, the Rajasthan government has informed that the High Court, it has drafted legislation to curb the menace of online gambling, and betting in the matter is presently pending before the appropriate authorities. Now, also the submissions was made by the counsel for the state before the bench of acting Chief Justice Mahendra Mohan Srivastav and Justice Vinod Kumar Bharwani, which was dealing with the public interest litigation filed to seek framing of appropriate legislation to curb the menace of online gambling and betting. Right? So that was what was in case, and having noted the submissions of the case, the court went ahead to dispose of the plea by making it open for the state to consider the matter itself. Now, with only one place on record, the statements of the Learned Counsel of the state has prepared the draft bill and the matter is under consideration, and also the Rajasthan government has prepared a draft deal for the menace of online gambling named Rajasthan Virtual Online Sports Regulation Bill in May of 2022. According to this, a virtual online sports commission will be set up to regulate online gaming activities in the state, and the offenders will face a penalty of up to rupees 2 lakhs for license and advertising violations. And also the draft law seeks to regulate fantasy sports and esports. However, it does not include skill games like rummy, poker and ludo, right? Because these are all games which require a certain amount of skill. अगर आपको पोकर नहीं खेलना आता, आपको नहीं पता कि हैंड कैसे होता है, then you will not be able to make money in that. So that is why it regulates fantasy sports, but it does not include skill games like rummy, poker and ludo. Now, coming to the next part, Islamic law recognizes Muslim women's right to demand divorce, husband's consent not essential. That's what the Kerala High Court has said. Observing the Islamic law recognizes a Muslim woman's right to demand termination of marriage, the Kerala High Court has ruled that the will of the wife cannot be reiterated to the will of the husband, who may not be agreeing to the divorce. Now, coming to the next part is that review petition against a judgment wherein the court has recognized the Muslim women's right to resort to khula. The division bench of Justice A. Muhammad Mastuki and Justice C.S. Das They were saying that in absence of any mechanism in the country recognizing the termination of marriage as the instance of wife, when the husband refuses to give consent, the court simply hold that khula can be invoked without the conjunction of the husband. That means that husband की जो consent है वो essential नहीं है for termination of such marriage. Okay, now the court at the outset of the 59-page judgment also said that typical review portraying that Muslim women are subordinate to the will of their male counterparts. This review does not look in caucus at the instance of the appellant, but rather appears have fashioned and supported by clergymen and homogenic masculinity of the Muslim community who are unable to digest the declaration of the right of the Muslim women to resort to extrajudicial divorce of खुला unilaterally. That means कि उनसे लिया नहीं जा रहा है इस बात को कि ऐसा हो रहा है, and they are being supported by the clergymen and homogenic Muslim masculinity of the Muslim community, right? Because उन्हें ऐसा लगता है. Now, road accidents that are involving any injury to the animal do not attract rash driving offences under section 279, 134 and 187 of the Motor Vehicles Act. Now, Karnataka High Court has said that section 279 of the Indian Penal Code, which pertains to the rash driving, would not be attracted to any accidents involving a pet dog or animals. There was a single judge bench of Justice Suraj Govind Raja who held that such accidents would also not attract liability under section 134 and 187, right? Because which pertain to the duty of the driver in case of the accident and injury to a person and punishment for offence relating to accident. Now the bench refused to read the word person used in these provisions to include animals and held that penal provisions must be understood in the literal sense. Now ये literal sense का मतलब क्या है? ठीक है, इसको कहते हैं हम interpretation of statutes, right? How is a statute being interpreted? So now the court has said that you have to interpret this statute in a literal sense. मतलब जो लिखा है उसका मतलब वही है. ये नहीं कि आप पर्सन के मतलब के अंदर आपने सोचा कि आप इसको इसका दूसरा इंटरप्रिटेशन करोगे, लाइक अ पॉजिटिव इंटरप्रिटेशन और गोल्डन रूल लगा के इंटरप्रिटेशन करोगे तो आप किसी को भी इसके अंदर इंक्लूड कर सकते हो. सो दे आर सेइंग कि जो लिखा है उसका लिटरल इंटरप्रिटेशन होना चाहिए, उसको लिटरल सेंस में लिया जाना चाहिए. अदरवाइज it was also said that in the event of death of a pet or an animal, the offence under 302 of the IPC will also be attracted, it remarked. ठीक है. Now the court also said that they are quashing this petition that is being said, and also said by the court in the absence of such a classification or such an offence being categorized, I am of the considered opinion that if the general principles of criminal law would have been applicable and the offence of section 428 or section 429 of the IPC will be committed, there must be a mens rea. Without such mens rea, matlab bad intention or without any animus to commit an offence is absent, it cannot be said that the person has committed any offence under section 428 and 429 of the IPC, right? So this is it for today, guys. Thanks for joining this live session. I hope you were able to catch up on some newses for the week. Do make sure that you hit on the like, share and subscribe button, and also don't forget to hit on the bell icon for all the regular updates. So thank you for joining this live session. Do take care of yourself and have a nice day ahead.